This video is a summary of everything that was said in the coins alert. Also, don't forget to like and subscribe to my station to get more XRP news and news about cryptocurrencies in general. Look at this now. With a new appeal that challenges a key XRP decision, the SEC steps up its fight against Ripple. Now, before we go any further, there is a new crypto airdrop going on Telegram that will soon start. Make sure that you take part in this airdrop. Just below the movie, there is a link. Do not miss this. Let's watch more of our movie. The Securities and Exchange Commission (SEC) of the United States has officially filed an appeal against a previous decision in its ongoing legal battle with Ripple Labs. It was the government that appealed Judge Analisa Torres's ruling about XRP, which is also known as Form C. This action has brought back the legal debate over whether or not XRP sales on cryptocurrency exchanges should be considered securities. In its first move, the Securities and Exchange Commission said that Ripple and its employees were breaking the Securities Act of 1933 by selling and marketing XRP without first getting the right registration. In the case of XRP, the SEC has asked for more information in a new investigation. For more information on whether or not the U.S. District Court for the Southern District of New York messed up the process with. Chris Larsson, co-founder of Ripple, and Brad Garlinghouse, CEO of Ripple, the government wants to know. The head of the Securities and Exchange Commission also asked for the problems to be looked into from scratch. This means that the court will go over a decision again because of concerns about how the law was applied. The chief legal officer of Ripple, Stuart Alderode, replied to the SEC's letter in an article on ACT. He said in the story that the business plans to send in its Form C the following week. He was the one who said, "This doesn't come as a surprise. It is now very clear what is going on. The people involved are not unhappy with the court's ruling that XRP is not a security. This choice must be followed because it is the law of the land." On October 2nd, the Securities and Exchange Commission filed its first appeal. It said that the district court's decision in the Ripple case goes against decades of Supreme Court practice and rules about securities. The people involved believe that the district court's ruling in the Ripple case goes against decades of Supreme Court precedent. They are excited to take their case to the Second Circuit. A spokesperson for the Securities and Exchange Commission (SEC) made this comment and said they were sure it was true. After the CC's appeal was filed, Ripple sent a cross-appeal to make sure that all problems were carefully looked into and dealt with. This was done by Alderode's explanation of why rights and responsibilities are important for making an investment contract clear. As soon as the Securities and Exchange Commission found out that ACU had raised $1.3 billion through sales of unregistered XRP in 2020, the legal fight began. Judge Torres' decision from more than a year ago was important because it said that Ripple's automated purchases of XRP, which happened through a blind bid process, did not break any securities laws. There were direct sales of XRP to institutional buyers, so she came to the conclusion that they were securities. After that, in August, Ripple was told to pay fines that added up to more than $125 million. Before this, the Securities and Exchange Commission tried to file an interlocutory appeal. Judge Torres, however, turned down the request because the CC hadn't shown proof that the appeal would significantly speed up the end of the case. The U.S. Securities and Exchange Commission, which is being sued by Ripple, chose to file an appeal even though the case is still going on. Several talks have taken place about when the appeal should happen. There are a lot of people who think that the Securities and Exchange Commission may not have filed by the due date. Information about what the case is about. The SEC has filed an appeal because of the way Ripple has been selling XRP on digital markets. Also, the part that top Ripple leaders played in these deals is being seriously looked into. The problems listed above make up a big part of the attraction. There are disagreements about the timestamp, and the timely filing of the appeal is now being talked about. There are some critics who aren't sure if the filing date or the time the documents were officially registered should be taken into account. Because of this situation, there have been fights between the many people involved. Brad Garlinghouse, CEO of Ripple, spoke out against the Securities and Exchange Commission's choice to make its own rules during this process. A $125 million fine has been given by the Securities and Exchange Commission (SEC) in the as for the lawsuit in question. It's more about the steps that are taken to sell XRP and how officials from Ripple are involved. In a broader sense, the Securities and Exchange Commission is looking into the matter. Mark Fagel, a former securities lawyer, says that the SEC's appeal is a step that is in line with what was expected. The main point of the appeal is not whether or not XRP is a security, but how it was given. In the world of digital goods, this case is being carefully looked into, and it's possible that similar things will happen again in the future. Because of legal laws and the fact that groups follow these rules, Ripple and the Securities and Exchange Commission are currently arguing. According to the pre-argument statement OCOMK that the USSC submitted, the regulators' SIME appeal in the Ripple case will not be about the legal status of the cryptocurrency called XRP. Scott Alderode, Ripple's chief legal officer, says that the court's ruling that XRP is not a security is the law. This was written in a social media post. Please explain what the call is for. Like everyone else, the US government is going after Ripple's sales of the XRP token on trading sites and its use as a form of payment. The SEC is going after Ripple CEO Brad Garlinghouse and co-founder Chris Larsson. Raz had to be punished again for supposedly helping and facilitating the sales that were reported earlier. In addition to the fact that XRP was given to staff members, the appeal will also focus on the personal offers and sales of XRP made by Ripple officials. It has been agreed that the CC will not file an appeal about the $125 million fine that Ripple was ordered to pay. In light of the final ruling that Judge Annalisa Torres made in August, this choice was made. Also, the CC did not file an appeal against the order to return the money. On the question of disgorgement, Attorney Fred Rispoli says that the Securities and Exchange Commission knew it was a losing argument, which is why it didn't bring it up as a Napoli issue. How likely is it that Ripple will succeed? There is a 90% chance that Ripple will win at least one of the problems. Jeremy Hogan, an expert in the subject, says that the information given is not meant to be taken as trade advice. Any purchases made based on the information on this page are not the responsibility of the people who made them. Before making any investment decisions, you should definitely do your own study and talk to a professional who knows what they're talking about.